So welcome everybody to this morning's discussion on the abortion law. My name's Ellie Lee. I teach sociology and social policy at the University of Kent, but I'm also the coordinator of an organisation called Pro-Choice Forum. We set ourselves up in the run-up to the 30th anniversary of the Abortion Act, actually, in the 1990s, and the first event that we did was held in 1996 at Oxford University. An event called Abortion Law in Britain, What Do Women Need and Want? And we've carried on from then, trying to do as much as we can to promote an informed discussion about the abortion law in particular. And one of the things we're very interested in doing, and always have been, is doing as much as we can as academics who spend our time in our day jobs studying and analysing the law and policy, to bring to light the insights of our research into other arenas, hopefully in a helpful way. So that's by way of explaining part of the reason why some of us in Pro-Choice Forum thought it would be a good idea to hold the discussion today. What happened, though, was, apart from the fact that, generally speaking, we're interested in organising this type of discussion, I found myself, really from the point at which the Telegraph sting happened, I can't remember how long it was ago, 2 or 3 months ago, starting to send round emails, particularly to Sally and Emily, but other people I know, arising from the fact that I'd turn on my computer in the morning, have a look at stuff that was in the papers, and my jaw would literally drop in the light of some of the comments and statements that were being made in public about what the abortion law apparently says, and in a complete, really state of utter bemusement about the level of stupidity, misinformation and wrong-headedness that was beginning to circulate in public domains about what the 1967 Abortion Act says, what's in it, levels upon levels of factual misunderstandings, misrepresentations of things and so on. And what raised alarm bells even more was that this factual inaccuracy and misunderstandings weren't only being put across by the usual suspects. So as we know, it's not new for the Telegraph to launch crusades against abortion providers, and it's not new for anti-abortionists to join in saying they think the abortion law is being flouted and so on. But what was much more surprising was that organisations who really should know what the abortion law says and should be able to say some sensible things about it appeared to be unable to do that. And some of the talks this morning are going to cover some of the problems that have emerged in discussions from that end of things. So really that was what gave rise to the cause for concern, was trying to do something which could kind of set the record straight. And also perhaps, and I'm hoping we can do some of that in the discussion, but also perhaps to have some kind of slightly wider discussion about exactly what it is that's going on at the moment that's creating a situation where this type of discussion about the abortion law goes on. Just to give an example for my own part of the type of thing that I mean, and I'm not in this sense trying to pick on any individual, but I had a kind of moment where my jaw was going like this. Listening to the radio a few weeks ago, Radio 5 Live did an outside broadcast from an abortion clinic. Much of this outside broadcast was very good, but the beginning of the discussion was about the abortion law. So I'm just going to read you out a little bit of the discussion, because for me it was quite a good example of some of the problems that we've got at the moment. The interviewer said to the person who works in the abortion clinic, "Let's talk about the legal side of things. Tell us what sorts of reasons women give." The person says, "We have ladies who say it's financial, they wouldn't be able to afford it, and that's not a legal reason, it's not good enough. Financially is not a reason to terminate a pregnancy. Like I said before, we have rape victims. So if I came into you and said I'm pregnant and I can't afford to keep this baby, would you say no? Yes, we'd say no. It's not a good enough reason to have that done." And you'd use those words to her, say that's not a good enough reason. Yes, yes. And there may be all sorts of reasons why this happened, but I was just really, really shocked that we could now be in a situation where actually even somebody who works for an abortion service is putting out on a radio broadcast the idea that with a woman who comes to an abortion service and says, "I can't have a baby because we can't afford to look after it," that would not be a legal ground. In fact, I can't think of a rationale that somebody would say that would more easily be able to be understood as perfectly legal under the terms of the Act. So really that's just by way of saying, by background, why we wanted to have this discussion today, and basically to recognise that I think we do need to have some discussion where we become a bit more clear in our own minds, although maybe lots of people here are already, about exactly what is the nature of the abortion law, and feel more able to take up some of the misrepresentations and misunderstandings that are around in the public domain at the moment, and as I say, have some broader discussion. The way it's going to work, as I think people know from my emails, is we've got 3 short introductions which are going to cover some of this ground in terms of misrepresentations of things, and go through exactly what the law does say. So my colleagues Sally Sheldon, Emily Jackson and Dorothy Flower are going to do short introductions. And then after that, the idea is we've just got plenty of time for people to raise whatever points they want, and have whatever discussion that would be the most useful. Okay, Sally.
Thanks, Ellie. So in terms of the division of labour between Emily, Dorothy and I, we thought it made sense for me to start off just by a very general, broad reminder of the parameters of the abortion legislation, just reminding you how that works in practice. And then I'll hand over to Emily and Dorothy to talk in a little bit more detail about some of the specific controversies around the law and some of the misinformation that Ellie was talking about in those 2 contexts. I thought it also made sense for me to locate the legislation in its historical context, because I think that's a very good way of reminding us what the law was trying to achieve, and that it was that historical context, the reasons for introducing the legislation, which really dictated the form that the law was to take. So there's a little bit of history, a little bit of a reminder of stuff that I'm sure is going to be familiar to people in the room. So to start off with then, just to remind you, if I take you back to Britain in the mid-1960s, we have a piece of legislation on the statute books, the Offences Against the Person Act, and this creates the offence of unlawful procurement of miscarriage. So it creates the crime of which a doctor or a pregnant woman who unlawfully attempts to procure a miscarriage can be convicted. It doesn't contain a defence to prosecution, so there's no defence contained within that statute. It doesn't distinguish between early and late pregnancy. In terms of the defence, however, a very creative judge sitting in the late 1930s read in a defence to this statute by looking at that word unlawful. So his reasoning was, if the Offences Against the Person Act talks about an offence of unlawful procurement of miscarriage, by implication there must be circumstances in which procurement of miscarriage can be lawful. The statute doesn't help us to know what lawful means, but let me borrow an interpretation of that word from another piece of law. And what he advised the jury in that case was that a procurement of miscarriage could be lawful where it was performed by a doctor acting in good faith for the purpose of preserving the life of his patient, where the continuation of pregnancy would be such that the woman would be reduced to a mental or physical wreck. So already then, in the 1930s, we've got this defence which is predicated on the idea of doctors acting in good faith. Just thinking about the social context of Britain in the mid-1960s, we know that abortions were being carried out at that time. We don't know how many, and estimates varied absolutely wildly between different commentators, so from 10,000 to 250,000. Some of those were abortions performed openly by doctors relying on the defence that had been created in the Bourne decision, the case I was just talking about. Others were performed in the back streets, and one of the concerns in the 1960s was this massive social inequality in accessing abortion. So rich women could pay to have a termination in Harley Street, poor women didn't have that privilege. And we know what the medical consequences of that were. So significant maternal morbidity, significant maternal mortality. 35 to 40 deaths a year is the official figure. Everybody agrees that the real figure would have been much, much higher than that, because doctors would often lie on the death certificate because they wanted to save the reputation of the the woman, of the family. And there's a lot of concern at that time as well about the broader consequences of that. So the idea that if the mother, who's a central figure in the family, isn't able to cope with the pregnancy or is injured in an illegal abortion, the effects of that ripple out. There will be children taken into care, there will be families unable to cope. Also very significant were the views of medical bodies that the legislation as it operated at that time was not a good basis for their members on which to act. It was a restriction of clinical autonomy. It was creating these inequalities of access. So that's the situation that the Abortion Act is introduced to remedy. And the solution adopted in the Abortion Act is unashamedly one of medical management. So we have this sense of a huge public health problem, and the idea is that doctors are the appropriate people to manage that problem. In the words of the Member of Parliament who introduced the Medical Termination of Pregnancy Bill, as the Abortion Act then was, David Steele says, if we can manage to get a pregnant, unmarried girl into the hands of the medical profession, the bill is succeeding in its objective. So you get these women into doctors' surgeries and the doctors will manage the problem. And it's very clear that that discretion is intended to be a broad discretion. So we're not just asking doctors to manage a medical problem narrowly conceived, we're asking them to also manage this broader social problem. Steele, again writing after the Abortion Act has been passed, I hope that the Abortion Act, by its very drafting, has encouraged the concept of socio-medical care. And I think it's important to remember that, because if you think about it in this context, then the legislative solution that's put forward in the Abortion Act just makes perfect sense. This is a massive public health social problem, and we're going to give it to doctors to deal with this problem, to regulate this situation. So you've got there on the slide section 1 of the Abortion Act, the bit of legislation that's introduced as a response to this problem. And you'll see, and I know this will be familiar to everyone in the room, a person won't be guilty of an offence under the 1861 Act, which I've already set out to you. When a pregnancy is terminated by a doctor, 2 doctors are of the opinion, formed in good faith, that the abortion fits into one of the 4 grounds set out there in the legislation. And in making that judgment, doctors are advised that they can take account of the woman's actual or reasonably foreseeable environment, so that the socio-economic factors are an essential part of that determination. There's 2 points I would really like to emphasise about this legislation, which hopefully then lays the groundwork for Emily and Dorothy to talk to you more about the current application of this legislation in 2 specific contexts. Firstly, the idea of discretion is absolutely fundamental to this legislation. It's in the DNA of the legislation. So some of this talk about doctors arrogating powers to themselves is really misplaced and misleading. This was a deliberate choice on the part of the legislator to carve out a very broad grounds for discretion here. So as Sir George Baker, President of the Family Division of the High Court, very senior family law judge, advised, not only would it be a bold and brave judge who would seek to interfere with the discretion of doctors acting under the Abortion Act, but he would be a foolish judge who would attempt to do any such thing, unless possibly there's clear bad faith and an obvious attempt to perpetrate a criminal offence. Even then, of course, the question is whether that's a matter that should be left to the Director of Public Prosecutions and the Attorney General. So the leaving this issue, giving this discretion to doctors, was fundamental to the operation of the legislation. Now, of course, there are limits on the operation of that discretion. So doctors have to certify that one of those 4 very broad grounds set out in the Abortion Act are met. And doctors have to form that view in good faith. And that's the second point I wanted to make, was just to talk a little bit about that good faith requirement. So in the Crown and Smith case in 1974, we have the one reported incidence of a doctor who is convicted for unlawful procurement of miscarriage, having actually obtained this second signature that's necessary to provide a defence under the 1967 Act. So it's quite a significant case. And Lord Justice Scarman, in the Court of Appeal in this case, so again, a very eminent jurist, says the Act, though it renders lawful abortions that before its enactment would have been unlawful, does not depart from the basic principle of the common law as declared in the Bourne case, which I've already talked about, namely that the legality of an abortion depends on the opinion of the doctor. It's introduced the safeguard of two opinions, but if they're formed in good faith by the time the operation is undertaken, the abortion is lawful. A great social responsibility is firmly placed by the law on the shoulders of the medical profession, and as I've said, that was an entirely deliberate choice of Parliament. If a case is brought to trial which calls into question the good faith of a doctor, the jury, not the medical profession, must decide on the issue. By leaving the ultimate question to the jury, the law retains its ability to protect society from an abuse of the Act. And I know Dorothy's going to pick up on this good faith requirement and how it applies in the context of certification requirements today. But I thought, given that this is the one reported conviction we have of a doctor who's got that second signature, it would be interesting for you just to know a little bit about how the good faith determination was made in this particular case. Good faith determinations are going to be a question of fact to be determined by the jury. So the prosecution is going to have to show beyond reasonable doubt that the doctor wasn't acting in good faith when he performed the termination or recommended the termination. Jury deliberations are secret, right? So we don't know what are the factors that carry most weight in the jury room behind closed doors. But what we have got in this case is the Court of Appeal looking at the conviction in Smith, deciding if it's safe, and setting out all of the factors which might have weighed on the jury's mind when they were making that decision. So I think it gives us quite a good idea of the kinds of factors which a jury would want to look at. So just briefly then to tell you what happened in the Smith case. Dr. Smith is a general practitioner with a private practice in abortion services. A young woman of 19 is referred to him seeking a termination. Dr. Smith spends a little under 15 minutes with her. He asks her why she doesn't want to carry on with the pregnancy. She says, I'm not in love with the father and I'm scared of childbirth. He doesn't perform any medical tests. He doesn't ask about her medical history. He doesn't do an internal examination of the woman. He says to her, if you can give me £150 in cash today, I can do the termination tomorrow morning. She says it will take me a while to get that kind of money. He books her in for the termination the following week. The kinds of factors I think would have been relevant to the jury here, or were certainly relevant to the Court of Appeal in discussing this case, are firstly, I think the fact that the money was asked for in cash raises some suspicion. The fact that Dr. Smith said immediately he could do the termination the following morning suggests that he wasn't that bothered about seeking the second opinion. The fact that he was acting significantly out of line with received medical practice at that time, I think would have been very important. So the Lord Justice Scarman says in this case, that's not determinative, but it's going to be a very significant fact for the jury to take account. What are other doctors? How are other doctors acting at this time? But I think probably most damning of all for Dr. Smith was the fact that he'd really tried to conceal his tracks having recommended the termination. So there was evidence that the registry of the nursing home where the woman was admitted for the termination had been falsified. When the police initially came to him and said, have you got, can we see your notes, your case notes, your records as the relevant certification of this abortion, initially he denied having any of that information. The jury found that he had lied about other aspects of what had gone on. So there's a clear attempt to mislead, to conceal, to perform the termination in a clandestine way. There's this very large fee, £150 wanted in cash at that particular time. So on that, I'm going to hand over to Emily.
I want to follow on from what Sally said and talk more about how the law works in relation to something very specific that has received a great deal of publicity, which is the idea of abortion on the grounds of fetal sex. So this story, which was reported in the Telegraph, as you all know, was immediately followed by statements like this, that termination on the grounds of fetal sex is illegal or unlawful. And this came from Andrew Lansley from the GMC and from the RCOG. Now, complete coincidence, I was teaching abortion law to my students that week. And so we started off the class thinking about this statement that abortion on the grounds of fetal sex is illegal in the UK. So I asked them, is that right? Is that correct? Is that what the law says? Well, some of them said, well, abortion on the grounds of fetal sex is not a specific ground for abortion. It's not one of those four that Sally had up on the screen, and I'll come back to it. It's not in that list. So they reasoned, as it's not in that list, it's not specifically covered as a good reason, therefore it's not a good reason. So that was the reasoning some of them employed. But that isn't how the Abortion Act works. And we could take another example of a reason why a woman might want an abortion to see how that works. So you could say the fact that a woman is pregnant as a result of rape is not on that list. It's not a specific reason in the Act as to why an abortion would be lawful. But the fact that it's not on that list doesn't mean that it's a bad reason. It doesn't mean that it's not a lawful abortion. So that list, which, as Sally explained, is very widely drawn, the fact that fetal sex is not on there doesn't necessarily mean that abortion on the grounds of fetal sex would be unlawful, just as that's the case with rape. Now, as Sally's explained, what the law does, and what it does very deliberately, is, and I'll go back to this slide, is leave it up to doctors to decide in good faith whether the woman's circumstances fit within one of these four statutory grounds. Now, obviously, the first one, A, is incredibly widely drawn. All that needs to be established here is that in good faith, two doctors believe that continuing the pregnancy would involve a risk greater than if the pregnancy were terminated of injury to a woman's mental or physical health. And health here has a wide meaning. We know that it doesn't need to mean that continuing the pregnancy would leave the woman a mental or physical wreck, because abortion was lawful before 1967 on those grounds. So this is introducing a much wider ground than the born exception. It's very simply a comparative judgment. Does the doctor believe that the woman's circumstances are such that continuing the pregnancy would be worse for her mental health than termination? So it is therefore possible that a doctor could conclude that the prospect of giving birth to a sixth son or yet another daughter would pose a risk to the woman's mental health greater than termination. Now, of course, in the vast majority of pregnancies, that's unlikely to be the case. Whether a fetus is one sex or the other is unlikely in most cases to affect the woman's mental health. But there could be cases where it would, and there could be cases where a doctor would form that opinion in good faith, which, as Sally has explained, effectively means non-negligently. Acting as a reasonable doctor, have you formed this opinion in a way in which a reasonable doctor would? And that would protect the doctor. Now, of course, you might find that there are doctors who have a conscientious objection to carrying out an abortion on the grounds of fetal sex. And a doctor would be entitled to have that respected unless the woman's life was at risk. But it is simply wrong, going back to these slides, to say that abortion on the grounds of fetal sex is unlawful in the UK. That is not what the law says. It is also wrong in this second statement to say that the Human Fertilisation and Embryology Act applies to abortion. It doesn't. The provision that's being referred to in the second quote here is a provision from the 2008 Human Fertilisation and Embryology Act, which prohibits pre-implantation genetic diagnosis for social sex selection. Now, that's interesting because you could take the fact that Parliament had decided in 2008 that pre-implantation genetic testing for social sex selection shouldn't be allowed. You might be able to take that and say, well, we can look at that and say, if asked, maybe Parliament would not like social sex selection using abortion. But Parliament has never debated this, and the words of the Abortion Act are clear and unambiguous. Now, it suggested to me that it's possible that more specific guidance might be issued on how the Abortion Act should be interpreted. So that somebody might say, well, we're going to look at these words and say, we need greater clarity, and that one of the things that might come in that greater clarity is some statement about abortion on the grounds of fetal sex. But usually, you would only get guidance on the clarity of what words actually mean, where those words are ambiguous. And I don't think there's actually any ambiguity in section 11A. Doctors have discretion over the decision whether the pregnancy poses a greater risk to the woman's health than abortion. How I see that what we've got is unbelievably clear evidence of the breadth of that discretion is that the words of this section 11A, are absolutely clear. It is the doctor's opinion that makes the abortion lawful. It isn't actually that those grounds exist. So an abortion would be lawful if the doctor had formed a non-negligent opinion that those grounds were there, even if they were in fact not. It doesn't say that abortion is lawful only if the woman's situation involves this risk. It's the doctor's opinion, and that is the trigger for the legality of an abortion. Now, there are all sorts of reasons why you could criticise the Abortion Act having this form, and I think Sally and I have both said before, well, maybe actually it should be the woman's choice, not necessarily a doctor's, but that's not what the law says. The doctor unambiguously states that the legality of an abortion depends on the doctor's opinion that it would be better for the woman than the alternative. So I'll now hand over to Dorothy to talk more about forms.
Good morning, everyone. It's really very good to be here with you all this morning. I've been asked to address the very specific and recently somewhat vexed question of the signing of the statutory certificate. I'm sorry, I'm not very tall, and I can't really see the people in the front there. I think this was made for a tall doctor, wasn't it, this particular bit? Before I begin, I just really want to explain my perspective, and I hope that's okay to take a minute or two to do that, because unlike my colleagues here, I'm not an academic, I'm a practicing solicitor. And because of that, I'm very much involved in how the law applies to my clients. So I am concerned with statutory and regulatory meaning and interpretation, but I'm much more concerned about what the enforcers of statute and regulation might do if any of my clients comes under criticism. And to a large extent, my job is to protect my clients. That can be prospectively by helping them with protocols and policies and so on, or it can be retrospectively by defending a client who's sued or investigated or prosecuted. So that's a kind of introduction to where I'm coming from. The second thing I want to say is that in the work that I do, I always aim to be objective and dispassionate. So although I personally am in favour of a woman being able to exercise choice, where this is the pro-choice forum, when it comes to abortion, I'm also willing to advise any client on his or her legal position, really no matter what side of the pro or anti divide that client falls. And I hope that that lends weight to what I'm going to say now, because it sort of demonstrates something of independence, really. Now, the subject matter of my talk, signing the HSA1, I'm going to look at this under 4 headings. First of all, what does the Act say? And we've touched on some of that. Then, what do the regulations say? Then, the question of what information doctors need before they sign. And then, what if it all goes wrong? And that's getting to the defence bit. Now, we've already looked at the crucial words in Section 1. It's the 2 registered medical practitioners of the opinion formed in good faith that one of those 4 statutory grounds is met. For the purpose of signing the HSA1, as Emily's already said, it's the words opinion formed in good faith that really count. And again, as we've seen to some extent, really all that means is that the opinion is a genuinely held, honest opinion. That's what good faith means. And that's not restricted just to medical law or abortion law. You get exactly the same concept in some other areas of law. So, for example, in company law, it appears, there's in every area of law where the good faith concept arises, it's associated with openness, with fairness, and with the exercise of discretion. As I've said, it applies in company law, for example, when directors of a company are making decisions about what is in the best interests of the company. And in that context, the courts have made it absolutely clear that the duty to act in good faith is entirely subjective. So it's not a question of whether the act turned out to be in the interests of the company, or whether a court might objectively, looking at it in hindsight, might think it was. The question, and here I'm quoting from a judge in 2000 in a court decision, the question is whether the director honestly believed that his act or omission was in the interests of the company. So it's about honest belief. Now, in exactly the same way, when it comes to the Abortion Act, the courts recognise that a doctor's good faith opinion is one that is reached subjectively. Sally's talked quite a lot about the case of Dr. Smith in the early 1970s, and as she said, the Court of Appeal made it very clear there that whether he'd reached his decision in good faith couldn't be determined by the court on the basis of, say, expert medical opinion and what the profession might think was a reasonable decision. It was for the jury to decide whether the decision was the doctor's honest opinion reached on his own assessment of whether a statutory ground was met. So the question of whether a woman and her pregnancy come within A to D here is for the doctors to decide honestly. The Act gives a little bit more help, as Sally has pointed out, in this subsection 2, where it says account may be taken of the woman's actual or reasonably foreseeable environment. And I think that's really helpful in two ways. First of all, it means that the doctor can look very much more widely than just the clinical picture and can take account of all a woman's circumstances, not just as they are now, but as they might become as a result of the decision that the doctor makes. And the other useful thing in that subsection 2 is the word may, because in law that means that the doctor can take that into account but doesn't have to. Then what do the regulations say? This is from the abortion regulations 1991, and this is really what is specific to HSA 1. It's just really the practical steps by which doctors confirm that they have reached that good faith decision. And certain practical requirements: the opinion has to be certified. The doctor can't just reach the opinion in his mind. He or she has got to put it in writing. It's got to be signed. The form, the HSA 1 form, is convenient, but it's not essential. And in fact, two doctors can sign two different forms. They don't have to be on the same piece of paper. But the certificate does have to give certain minimum information. That's listed there. And the doctors have to sign the certificate before treatment begins, and they have to agree on the same ground for abortion. So a doctor could believe that more than one ground applies, but the two have to agree on at least one. You'll all know that the HSA 1 form doesn't follow precisely the grounds set out in the Act. There are, of course, 4 grounds in the Act and 5 categories in HSA 1. I'm not going to trouble particularly with that difference now, but effectively for our purposes today, grounds C and D, or categories C and D in HSA 1, are all contained within in A, subparagraph A of the Act. So now and this has become a vexed question, what information do doctors need before they sign the HSA 1? And the real answer to this question, if you are a doctor, is that it's up to you. You can decide what information you need to enable you to form that opinion in good faith. Now, that's very open, and so just to give you a bit of assistance, bearing in mind what a court might be interested in, I thought I'd give you a couple of pointers. The first thought is that there will be some general questions and answers that you have in your mind because of your experience and qualification and expertise. So first of all, what do you know about the physical risks of abortion when compared with the physical risks of continuing a pregnancy to term and giving birth? Now, that's a question for you as medical practitioners and not really for me as a lawyer, but my understanding is that as a general rule, abortion is physically safer. I don't need to enumerate the various health complications that can arise in and as a result of pregnancy, but that's one thought. Secondly, what do you know about the psychological and psychiatric risks of abortion as against pregnancy and birth? And on that, we have the recent review published in December of last year by the National Collaborating Centre for Mental Health, which found that the risk factor for an adverse mental health outcome is the unwanted pregnancy, and that's really regardless of whether that's resolved by abortion or giving birth. But after that, the review supports the idea that a woman is less likely to suffer an adverse mental health response if the resolution of the unwanted pregnancy is of her choosing. In other words, if she's got some control in the decision-making, the choice that's made. So a woman who clearly decides to have an abortion, that she wants an abortion, but is refused, is just as likely to suffer an adverse response as a woman who's forced to have an abortion against her will. So if a woman is seeking an abortion and very clearly determined that that's what she's wanting, then the assumption must be that her mental health is better protected by allowing her to make that choice. So those are general factors. Based on those alone, my view is that a doctor could be justified in signing an HSA1 without knowing even the name of the woman. Which means that there could be a basis for saying that pre-signing of an HSA1 is not in breach of the law. But because of the requirement to include, for example, the name and address of the woman and so on, and because of the attitude that regulators have taken, my personal view is that's not a great idea, but I don't think it's in breach of the Act. But what about factors that are specific to the woman, factors which might alter that sort of balance in the doctor's opinion? And again, I think there are really 2 points here. One is that it's for a doctor who's asked to sign the HSA1 to request whatever specific information he or she wants to see before signing. In some cases, it might be appropriate to see all the available records, notes of the consultation, details of past medical history, and so on. But in the vast majority of cases, reviewing those records will probably make no difference at all to a doctor's decision. Now, I realise that's quite a bold statement, so I'm going to illustrate it with an example. It actually fits in quite well with Ellie's introduction, about which I knew nothing in advance. A woman seeking an abortion doesn't come along and say, I want an abortion because the risk to my mental health is greater by continuing with the pregnancy. She just doesn't say that. She says, my family's complete. Or she might say, financially things are a mess and I can't afford to have a baby. Or I've broken up with my boyfriend. So now none of those is expressly one of the 4 grounds in the Act. But each one of them might well be a relevant factor, or is, in fact, a relevant factor for the doctor to take into account, which might tip the balance of the mental health reaction and make it more likely that an adverse reaction will follow going ahead with the birth. So those are important factors. Similarly, if a woman has revealed that she's, say, suffered from preeclampsia in her previous pregnancies, that might tip the balance so far as the physical health is concerned. I say no more on the medicine side of it. So does that mean then that a doctor needs to check the records to look for that kind of tipping the balance information? And that brings me to my second point. The law recognises that in the provision of abortion services, doctors work as a team with nurses and other staff involved. So in 1981, in a case that was brought by the Royal College of Nursing and which went all the way to the House of Lords, as it then was, Lord Diplock said that Parliament contemplated, so we get back to what was the intention of Parliament, Parliament contemplated that, like other hospital treatment, that's abortion, would be undertaken as a team effort. And it would be in accordance with accepted medical practice to entrust treatment to a member of staff possessed of the respective qualifications and experience. Now, just again, by way of an example, part of the certification process is that a pregnancy has not exceeded its 24th week. You can see that at the beginning of A. But that doesn't mean that the signing doctor has to scan every woman or examine her in order to check gestation. The doctor's not even required to see the woman. He or she is entitled to rely on the assessment of gestation that's performed by an appropriately qualified member of the team. If that person has some doubt, he or she could seek the advice of a doctor. But if the team is experienced, that's probably going to be very rare, if not the exception. And in exactly the same way, my view is that a doctor's entitled to rely on the appropriately qualified and experienced members of the team to draw to his or her attention any factor which might make the doctor think a little bit harder in the balancing exercise, thinking about the relative risks of abortion versus continuance. Now, I was just going to spend have I got 2 minutes still, Ellie? Okay. Just the what if it all goes wrong bit, because I am aware of a recent example where things could potentially have gone wrong for a clinic when a CQC inspector decided that doctors couldn't sign the HSA1 without seeing the woman's records. And the CQC report said that there was a lack of proper information available to the doctors who sign, and that resulted in a failure to ensure that people are protected against the risks of unsafe or inappropriate care and treatment, and that was said to be in breach of the regulations. You'll realise from what I've said already that I think that comment is entirely inconsistent, not only with wider practice and regulatory enforcement, and it's notable that other CQC inspectors in other clinics where the practice was identical were finding that there'd been compliance, but it's also inconsistent with the legal requirements for all the reasons that I've explained. I simply can't see that it's for the regulator to prescribe how any individual doctor reaches his or her decision in good faith. For an individual doctor, things going wrong is likely to mean that there's an allegation that the decision in an individual case was not reached in good faith, and so the abortion which followed was unlawful. Now, I don't need to tell you that that has the potential to be very serious for the doctor. There'd be the involvement of the GMC. There could also be a criminal prosecution and possibly a civil claim. Defending allegations like that will be all about the evidence. Now, that will be, of course, the evidence of the doctor talking about how he or she reached the decision. But it's also going to be the wider evidence that underlines the doctor's decision-making. And so that will include reviews and studies that inform a gynecologist's expert knowledge and the practice and expertise of the staff and the clinic on which the doctor relies. That's going to be important evidence. And I just want to make 2 points in reassurance. The first is touching on the Smith case. As Sally said, that's the only decision that she's aware of and that I'm aware of since 1967 where this has come before the courts in this way. And it was 40 years ago. So there's no reason at all to think that a case today would be decided in the same way as the Smith case. Apart from anything else, the very fact that the question goes to the jury is going to be important because the attitude of any jury should be very different now from in the early 1970s. The second point is that I rather suspect that the Crown Prosecution Service would think very hard indeed before bringing a prosecution now on any but the most obviously criminal grounds. Certainly in the civil law, the court has shown huge reluctance to make any kind of decision which at a stroke turns a whole raft of law-abiding citizens into potential criminals, which is what such a decision would mean. And that was put into words by Lord Keith, again in the RCN case, when he expressed relief that, that it was unnecessary to reach a decision that would make very large numbers of medical practitioners who've participated in the relevant procedure over several years guilty of criminal offences. And Mr. Justice Munby, in the case that involved Spuck's challenge to pharmacists dispensing the morning after pill, said something similar when he said that to hold what thousands, I think he said hundreds of thousands, of ordinary, honest, law-abiding citizens have been doing is and always has been criminal would be grievously wrong. And I have to say I agree on this occasion with Mr. Justice Munby. So thank you.